It is recording.
Yes, it's at the foot right there.
Okay, great.
Back taxes. We have it's not my keyboard, is it? You can, I don't know where it goes to, but come on. So Caroline is asking for.
Well.
Oh. Result of, once a week or once a month.
It's more than once a month. Yeah, and there's also a hearing.
Also, I have. That's the big one.
Yep.
I was gonna say. Yeah.
We'll make that decision.
Yep.
Yes, yeah, this.
So it's. I don't think we hear that. Mrs. Peter starts the AC in March, continues it to November.
Oh, we got solar.
No, this has been a 40-some year place. I wake up in the middle of the night, I go turn it off, in the middle of the night, it's back on. It's a little terrible.
The father-in-law used to be down in Pennsylvania, the way it's so hot. Creep around in the room, turning off all the fans. Because he was from childhood depression, nobody's up, you know.
Yeah. So is this, we're waiting for this to be turned on?
Yeah, I just want to make sure we actually get the recording. Traffic coming down this way, a little bit, I get stuck.
I came from Portsmouth.
Yeah.
The traffic going over the Newport Bridge is unbelievable. They're doing construction. but
Coming the other way.
Yeah, that,
Bumper to bumper.
yeah, just why?
Should be recorded. Okay, we're good. Audio's good. Yeah. Nice. Okay. So thank you for being here, everybody. Freedom.
Yeah, so we called this as a pre-hearing conference just to get the ball rolling, and it started in 2019, so. While you've styled your motion as an emergency. I've been here all this time, but we're gonna consider it. Mr. Hartley will give you an idea of how we're gonna do that.
Sure, absolutely. And so today is just the hearing on the emergency motion. Because it's been stylized as an emergency, we wanted to expedite the hearing process, the pre-hearing process. To let all parties be heard. But I want to emphasize there are other motions that are still haven't been heard yet. Eventually, the hearing officer will get to those, but today is just for this emergency motion to hear what the parties are thinking and to try to come to some sort of resolution with that particular motion. So if the objectors would like to present, then we'll give the applicants an opportunity to respond.
Good morning, Mr. Krieger. Don Libby, hearing pro se as an objector. We filed this because on about the 26th of June, we had a new statute go into effect in Rhode Island that the objectors believe covers the area where the applicants are proposing to have the aquaculture farm.
It physically covers it or?
Physically covers it. And we thought that since it went into effect and we had the revised scheduling order in effect, we filed it as an emergency so that we could discuss with you the steps forward here, whether we should be going to a full-blown hearing based on the existing statute. And, you know, is it necessary to go forward with a full-blown hearing with respect to the application, which requests a commercial aquaculture facility in Sepauwett Cove. It's now been identified, and the boundaries of which contain their proposed farm.
And when did the objectors allege that this law took effect?
June 29th, effective June 29th.
Was effective upon passage. The governor did not sign the bill, but he sent it to the Secretary of State.
So what are the words effective upon passage mean then?
My understanding is it means that it becomes effective upon passage. So the day it passed, which would be the 29th, once the governor didn't sign it, but he sent it on to the Secretary of State, it became state law.
And what is your position as to how that affects this application?
For myself, and I believe the objectors, we believe it precludes USER and the SARMs and council from approving this because the new law prevents and prohibits commercial development in Sepauwett Cove
As of when?
as of June 29th.
And how is it that this law goes into effect post facto?
It's not ex post facto because in this instance, the applicants at this point, and this isn't going to be all our arguments with respect to this for dispositive motion, but it's our position that it does apply to them because there's no, even though there's no retroactivity with respect to the new law, filing a application for an aquaculture farm does not give them any vested rights going forward. So the law that applies is the one that is in effect now. And as a certain justification of that, if you look at the zoning statute, and I don't have the number here in front of me, there's actually in the enabling statute a section that says creation of vested rights. And it specifically calls for that in the zoning statute.
What zoning statute? Town of Tiverton's?
No. This is the enabling statute for zoning in the state of Rhode Island.
Which we say does not apply to this instance.
Well, if it applied, it would be called spot zoning.
Well, it just doesn't apply. The enabling statute for the CRMC and in the Red Book, there's no provisions at all for vested rights. The Bowens have neither a contractual right or a property right here, so they have no vested rights. So what they have now is an application for a lease of public trust property. They have no property rights. In the zoning context, a developer either owns the property or has an agreement, a contract with the owner to go forward. So in the zoning context, you have vested rights. And so the General Assembly has provided for specific vested rights in the zoning context. The General Assembly specifically has not provided for any vested rights in the CRMC context. If you look at the enabling statute, the Red Book, there are no vested rights. So what the Bowens had on June 29, 2024 was an application to lease public trust land. That's all they had. So right now, as of today, that statute applies, which clearly prohibits commercial development in the cove. And not only it goes even further than that, it says it can't be changed from its current undeveloped state. So it's even they don't have an application, by the way, for a recreational lease. They don't have an application for an experimental lease. They have an application for a commercial lease. It's clearly prohibited by the statute. So
I'm sorry, go ahead.
the statute is 32-1-5.2, which in the title of the statute, it's literally called prohibition of development. So there's nothing ambiguous about it at all. And we would just like the opportunity to provide you with a brief that explains this in detail. And obviously, the Bowens have an opportunity to respond and show you any law that they think might apply, that they might have some kind of vested rights. But that's really, I think, the issue here, of cutting through everything, is on today's date, on June 29, 2024, did the Bowens have any vested rights by virtue of the fact that they've submitted an application to the CRMC? And that's really the legal issue, I think, that we'd like you to decide, because it would really save everybody a lot of time going
I
forward.
agree. I fully agree. That's what we're attempting to do here, is to consolidate things so that we can either proceed or, if the court finds that this is, can be applied retroactively, then that's the case.
Yeah, so,
What do you say to the cases, though, that are at odds with your position?
so that there are none. So now let me explain. We're not taking the position that the statute applies retroactively. We think the statute may apply retroactively or may not apply retroactively. We don't care. Because we're talking about June 29, 2024, when it became effective. We look at that date, we have a prohibition on development in that code. What do the Bowens have? They have an application for a commercial lease in that code to lease public trust property. They don't have a property interest, they don't have a contractual interest, they don't even have anything from the CRMC, any approvals from the CRMC. So it's our position, they have no vested rights, therefore it's prohibited. And we'll lay it out in more detail in the statute. We'll provide you with the case law that supports that. But in general, and there's no statutory vested rights here. There's no common law vested rights. There's no property interest. There's no contraction. That's really not going to be our argument. But we'd like to, give it to you with a brief. We'd like, a couple of weeks to do that, and obviously give the Bowens an opportunity to reply. And if you heard on it, if you want to ask questions about it.
So what do you have in plan?
Not at this time.
Ms. Jessica? Owen? What do you say?
Mr.
about-
Krieger, so it is our contention that our CRMC application is a de facto contract in good faith on the parts of both the CRMC and applicants. And were it not, it would seem to me that this entire application process would lose any credibility. So we do in fact believe that our application, which was submitted again in 2019, initialized this, that in fact it does precede certainly, and it would in fact still be in effect. It is noteworthy that this process, which typically takes about a year for approval or so, that being an aquaculture lease application, our process has been significantly delayed through certain objectors, retention of counsel,
Mhm.
and delays on the part of counsel and objectors for a specific purpose. It also should be noted that this is the third year in a row in which specific legislation was introduced to specifically target our aquaculture lease. Now, when one reads the statute 32-1-2.5, in fact,
5.2.
5.2, right.
okay, I'm looking at this on the statute itself, but it is in fact, so Mr. Libby had then sent me in his correspondence. I'm on page 2 here,
Mhm.
wherein he cites the clear and unambiguous language of the Maryland General Laws 32-1-2.5 in his motion. So that would be
Yes,
incorrect.
that's a typo. This is-
Well, a typo which could have repercussions, but that notwithstanding, my point would be that, in fact, this legislation is extremely unambiguous. Or ambiguous, I should say.
Ambiguous.
Yeah, it lacks specificity, both in terms of the boundaries, exactly where these coordinates are that restricts this. And it also makes reference solely and only to the waters within Sepauwett Cove. It is our contention that what it is we've applied for is a bottom lease of submerged land. So there's nothing in this statute that refers to submerged land. And it further enables the Rhode Island Department of Environmental Management to lease any part of the land within the management area. And it would be our contention that this submerged land would in fact be included within.
Well, that brings up a question that I had, for any of the attorneys representing the objectors. How is it that, the legislature, by this statute, can expand the Sepauwett management area to include the entirety of the coastline? How is that, how does the legislature have that authority?
Well, okay, first of all, I want to say that the applicants don't dispute that they are subject to the new statute. In their objection, they haven't even disputed that. So the issue of vested rights isn't really an issue. What they're saying is the statute's ambiguous and doesn't apply to us. If the statute's ambiguous, and at the same time, they're saying that the intent of the legislature was to target them. And guess what? If a statute's ambiguous, you look to the intent of the legislature. So the intent of the legislature was to eliminate aquaculture in that area. We agree with 100% of the.
I object to that.
We agree 100%. If it's our position that the statute is not ambiguous in any way. Section A applies to the DEM, it applies to land. Land, they talk about leases. Section B applies to the CRMC, which is the CRMC's exclusive jurisdiction over the waters. And the General Assembly is the only body that could expand the DEMs and the CRMCs. That's who does that. So we think they have the power and authority to do that. To the extent that the statute's ambiguous, we look to the intent of the legislature. And we could supply you with testimony where it's very clear, and the Bowens, one or both of them were at a lot of those hearings, where it was clearly made crystal clear that the statute applies to this aquaculture farm coming up. It applies to aquaculture farms. So we think it applies unambiguously. We think it clearly applies, and we'll argue that in our brief. But to the extent that you think it's ambiguous at all, okay, let's look at the intent of the legislature. It was to eliminate aquaculture in that, as the Bowens just admitted.
I did not admit that.
Yeah, no, we
I
have
did
not, as a matter of
And I
fact,
dispute that.
agreed. Our contention is, we predated
This
this.
is a pre-hearing conference.
Sure.
This is not trial.
As just about every legislative hearing, Representative Edwards or Senator DePalma both stated, this is not about oyster farming. Each of them stated that at each hearing. So I dispute that.
They state it was for
The protection of natural resources, presumably. I also would say that there's nothing in section B of the statute that references CRMC at all. As
I think what Attorney Wagner's saying is that CRMC by statute has the control, if you will, over the navigable waters and
Sure.
wetlands, estuaries, and so.
And the other point I would make with reference to ambiguity is section B references no coordinates, but an area called Sepauwett Point. It doesn't exist. There's no pin in the ground from where 2,000 feet begins or ends, so it's an immeasurable point. It has never been established.
And we'll dispute that with applicants. Well, that would, it's an issue for them, which we don't think it's an issue. We think it's ambiguous.
It would seem as though in order for this, for the argument that opponents are making, that the CRMC would in fact have to cede their rights to this area in question. And I would also suggest that based upon what's
You mean see their right to control the area?
that's correct.
So we
So
disagree. We think that the statute's clear that there are certain things prohibited, commercial development being one of them. That doesn't mean that CRMC might not provide something else could go there. And I don't want to throw anything out. I don't want to give the Bowens any ideas yet, but I'll certainly give you more ideas of that later. But for example, an experimental kale farm might be something that
kale is a terrestrial crop. Kelp.
Kelp, I'm sorry, thank you. Showed my ignorance. Experimental kelp farm might be something that is not commercial and it fulfills the function. I think that's not recreation, so that wouldn't work, but it doesn't mean that nothing can go there, or it doesn't mean that, but it clearly means that there can't be any development there. CRMC still has jurisdiction over it.
I would contend that aquaculture is not development. It's a temporary use of public area. It's not development at all. We're not intending to put up any permanent structures, modify anything. It's a temporary use of public area.
Yeah, and we'll show you,
Coalition bond is necessary.
and we'll show you the definition in the red book that speaks that. That's why we need it.
And it does fulfill the requirement of being restored. Because from our initial application, we have stated that we intend to culture diploid oysters capable of reproducing, which have the tendency to increase natural recruitment in the area and have wild oysters all over the place. And that has happened in other places.
Well, let me ask Jeff, is there some area that this legislation purports to control? Is there some
Yes.
portion of this area that would be agreeable to your clients for oyster aquaculture?
No, not only would it not be agreeable to our clients in the Sappowood code, but it's prohibited by the statute. And it also says, what's prohibited is any modification of this current undeveloped state. The General Assembly couldn't have been more clear that it's not supposed to be any development in that area. And we'll give you an affidavit as to what that area is, if they're confused about it. But no, we think there's tons of great spots for aquaculture farms, but not in the Sappowood code.
Because why?
Because it's prohibited from what the General Assembly decided that you shouldn't be any development there. And we'll give you, there's a public parking right there. This is a place that is for recreational use. It's been used for years for recreational use. And it's just a terrible spot for an aquaculture farm. That's what we're going to show at the hearing if necessary, but we don't think it's necessary because the General Assembly has spoken. They've said this is a terrible place for aquaculture. It's a terrible place for any development. This should be for passive recreational use only. And in the statute, the only issue is whether the statute applies to that. And I think it's pretty clear that it does, and we'd like an opportunity to brief it for you.
I think what the statute says is that you can't have floating gear. You can't use the water. You can't have floating gear. You can't commercially fish. If you're a commercial fisherman, you can't, it's prohibited. I think if you had a party boat to come in and it was commercial, you would be prohibited from coming in there. But to utilize the bottom, analogous to terrestrial farming, they have a lease of land, and that's what we have been seeking for 4 years.
So are you, by this law, are you saying that the General Assembly can just do this with any of its recreation areas like the woods, for example?
Yeah, absolutely. And the CRMC gets its enabling statute from the General Assembly. It's a state agency. So the CRMC is controlled by the General Assembly. They give them their authority. They've specifically limited their authority here to pass any applications in the Sappowood code. That's what they've done. They clearly have the authority to do so. And we can certainly give you some case law or authority for that if that's an issue.
We believe that the precursor to 32-1, what was the statute? 32-1-5.2, which is 32-1-5. The general provisions allows DEM to rent or lease such parts of the parks or reservations under its control or any building thereon, and may grant concessions on or about those parks or reservations as in the opinion of the director may deem necessary or advisable, but not for periods in excess of 25 years. The precursor to that new law allows DEM to lease land.
Yeah, that's why it's an amendment to that law that says you can't do that here. So we agree with you that there.
I would also suggest, as to the emergency nature of this motion, that there are in fact commercial fishermen who use this very same area. And from the standpoint of an emergency, it would seem to me that the state has a greater responsibility to those people in the state who make their living.
We're already in
Commercial fishing,
business.
Conking, lobstering within that area. And I would ask whether or not any notification, emergency or otherwise, has been given to any commercial fishermen's associations regarding use, now alleged prohibited use of that code.
Well, that's for the General Assembly. You can go to the General Assembly.
But it
That's
would
not
seem
the
to
hearing
me
officer.
the DEM or the CRMC, my request
It
is,
would be a consistency.
that's it. If this is an emergency for a 4.5-year application, well, there are people trying to make a living right now who perhaps are fishing in waters that the legislature just banned.
I think,
That
Mr.
was-
Springer, if I could, the purpose of the emergency was we had a revised scheduling order. We have a new law, we think it applies, let's pause and talk about it. That was the purpose.
Right, well, you, I noted in your motions, you did. You alleged that you were gonna file these motions by the 10th, so I'm assuming that you haven't filed any. No, I haven't seen.
Yeah, we moved to stay, so we'd like to have at least 10 days to 2 weeks to give you a brief with an affidavit.
Mhm. And with case law, addressing the point of, the effective date,
Sure, yeah.
have you gentlemen, been able to do any research with regard to that? Any case law? With regard to the point that I brought up,
Which point specifically?
about when this act goes into effect and whether it also would be applicable to your case in particular.
I haven't done any research, but it would seem that that would add to the ambiguity of the statute.
Well, I would suggest that if they're gonna present cases that on their side, it should be prudent for you to look these up.
I would say that when we submitted our application, we did it 4.5 years ago. We did so under all the rules and guidelines from CRMC. That process changed, and we got all of our,
When did it change?
it changed in 2021, 22. We rebooted and got all of our approvals a second time. So now it seems that it's changing a third time, and it's a moving target, and that doesn't seem just.
I don't disagree, but what I'm saying is, they're looking for 10 days. Is 10 days gonna be adequate for you to research this and submit a reply brief, or would be your?
So we would have to see their brief first, right?
Right.
We submitted our brief, our initial brief.
Mhm.
I mean, at this point in time,
You submitted your brief prior to the enactment of this.
We did.
at this point in time, we have no intention of withdrawing our application. And so
I don't expect you would.
it is the case too that laws can change. We would hope that this particular statute will be changed in perhaps the next legislative session, but all that aside, in the short term, is 10 days a reasonable time? I mean,
We'll do what we
take
are
30
able to
days,
do.
whatever it is, we're not gonna be withdrawing our application.
I don't
It
think
should be clear to be 10 days from after the objectors file there.
Okay,
You'd have 10 days for, yeah. Unless there's need for more.
I think that would be okay.
Does that give you enough time?
I think it does, sure.
And the other,
You're gonna submit a 400 page.
the other deadlines would then be
We'll have
stayed
We'll
and
have
then
to adjust all of them.
decision on the positive motion.
Yeah, well, so exactly, so part of pre-hearing conference and to get everybody around the table today, part of the reason for that is, let's figure out first, are we gonna have briefing on dispositive motion, and then second, what do we do with the regularly scheduled, the amended schedule order?
Yep.
So 10 days from today would be the 25th, which is a week from Thursday. Enough time for you?
Yes.
Motion. Move. 7:25. Yes. August 3rd, which is Saturday, so it's August 5th, which is Monday. No, but and again, I'm, your pros say that's your choice, but I'm trying to go out of our way to not to assist you, but to accommodate you in that position. So I mean, it would be my suggestion, even though you're right, you're gonna get their brief, you give you time to reply to it. I would be doing some research between now and when they submit their brief, so that, we have enough time to respond. That makes sense?
It absolutely does, and with regard to the pro se element of this, I would only inquire, it seems as though many of these motions have been submitted by Mr. Libby, who himself is pro se, and that other objectors have signed on to his pro se motions.
Yep.
At what point in time does Mr. Libby's actions constitute a legal representation of other opponents or objectors?
Just so you know, we've been submitting all motions jointly. And we've been, so it is not Mr. Libby submitting things and us signing on. That's not the case.
Oh, you may recall the first hearing we had on this up in Providence, Mr. Libby and Ms. Desitel were appeared by Zoom, but I did bring to Mr. Libby's attention, what he's trying to do and to not run afoul of laws we have in the state of preventing the unauthorized practice of law. It's not up to me to determine that. But he's certainly aware of that. Correct?
Absolutely. I'm representing myself. I just happen to have a common interest with the other two objectors.
I hope that you could understand my point insofar as when motions are received by us, they have come recently from Mr. Libby and have been endorsed effectively by the other two attorneys present.
There are also laws pertaining to ghostwritten material from lawyers that aren't taken. And I hope the Bowens become aware of them to the extent they are speaking with lawyers that are not putting their names on the briefs, that there are laws with respect to ghostwritten briefs.
I appreciate that. Thank you.
Thank you.
Okay. So Libby, do you have anything else?
My only suggestion, Mr. Krieger, is that get through the dispositive motion before we start picking things through this thing. Because there may be no purpose to pushing those dates out if we have success on the dispositive motion.
If I may inquire in that regard, Mr. Hartman, do you feel as though the hearing officer has the adjudicative authority to hear a dispositive motion in this case?
Why? No offense, you
No.
don't have access to CRMC.
Opinion.
Only as clerk of this proceeding.
Say he's not the clerk, he represents the council, and the hearing officer is an independent adjudicator of the matter. So what Mr. Hartman thinks about Mr. Krieger's scope of jurisdiction is not appropriate. I don't want to.
So by way of clarification, then, is it the case that your presence here is only representative of CRMC?
Well, I represent the agency, and as part of that, I represent Mr. Krieger and the council. And I think that I don't want to, while I recommend what actions may be appropriate for Mr. Krieger, I don't think at this time, before the parties have briefed the issue, it makes sense for me to comment on.
Would you be willing to answer that question, whether or not you feel you have the authority to dispose of this matter?
Well, that's
Yeah,
I'll have to see the.
and we'll make it clear if
motions,
necessary in
I'll
our
see the
briefs.
motions and your response to determine if any issues have been raised that would give me pause from considering motions. But right now, according to the statutes that set up the CRMC, the statutes that set up the hearing officer, and you realize that the CRMC has never had a hearing officer until my appointment last year. But as far as I can see, this is certainly within my purview to take their motions, your responses, testimony, exhibits, and so forth to make a decision.
And to be clear, Mr. Krieger's authority is a recommendation to the council, so the ultimate authority.
I guess that was the root of the question, right?
Effectively, yes, yes.
And they can choose to adopt my suggestions, to modify them or to reject them.
Thank you. Thank you.
know, the CRMC has had, you know, they've been in the news a lot on various issues and so forth. That's why we want to make sure that everybody's aware that this is an open process. That being said, when we schedule hearings on these motions, I'm considering where we're gonna hold those hearings. Because we don't want anyone, whether it be you, the objectors, or the John Q. public, to say that, oh, this is CRMC doing backdoor deals. You know, meetings that only the seven of us are after. That can't happen.
If I could, Mr. Krieger, I'm confident that you as the hearing officer have authority. And I say that because you are the finder of facts. You can determine whether the facts are in dispute or not. And then rule as a matter of law. So I think on dispositive motions, you do have authority, at least in my opinion.
Thank you, Mr. Libby.
I asked if Bowens have any comment on the extension or stay of the regular meeting schedule. Do you have an objection to that, as Mr. Libby had proposed, or we prefer that the briefing schedule be amended today? And again, to be clear, the remainder of the task and the briefing schedule are the objector's responsive brief to your pre-hearing brief, as well as submission of exhibits from both parties.
Which would do tomorrow. Exhibits is due tomorrow.
We're gonna have to modify it.
And that's, I guess, the answer to the question based upon what has transpired. That we will have to have a modified.
We're not prepared to submit our exhibits by tomorrow.
Right, so yes, because of the stay, nothing's being submitted right now. What we need to
We were
do.
preparing in that regard until the emergency stay came.
Mr. Krieger's prior order ends today, the stay ends today, so we need to determine what's going to happen with the amended scheduling order. Mr. Libby has proposed not continuing that scheduling order until dispositive motion has been handled. But the other option is to have set dates for the regularly scheduled brief, which would be objectors' responsive brief and submission of exhibits.
So we have August 5th being the Bowen's reply to our dispositive motion. And we don't know when the hearing for that will be scheduled, so it's hard for us to put out there a date at this point.
Sure.
But certainly, you know, to the extent that the dispositive motion, the hearing of the dispositive motion does not resolve the case, then we're gonna have to have a date for the pre-hearing brief and exhibits. It makes more sense, well, I'll let you do what you want. It would seem to me, we don't know when the hearing's gonna be scheduled, so we wait till the hearing, and if the hearing case is not resolved, then we set dates for the exhibits.
So my thinking on it is that when we do have a dispositive motion, that has to be a hearing. That has to be noticed. That has to be
Absolutely.
my recommendation per our normal practices to hold in Tiverton.
And be advertised in the journal or they advertise.
However staff advertises. So if that dispositive motion is going to be hearing, I don't want to go back to,
Is that required to be an in-person hearing by statute or just positive motion?
not by statute, but that is going to be in person.
And you said Tiverton?
That's going to be my recommendation to the hearing officer
Why?
based on past practice.
Because the hearings are normally heard in the venue with the application or violation stems from. I know you filed motions to not hold the hearing in Tiverton. You know, sort of suggested to you that this isn't a jury trial. We're not pulling people from Tiverton to decide your case.
Well, effectively, with a hearing in Tiverton, that would be,
How do you mean?
well, by virtue of location, It's easier for people in Tiverton to attend that.
Which
Whether-
is why the,
Yes.
that's why the agency
Right.
has a past practice, because it wants to increase public involvement and activities that are occurring in that area. That's why it holds it to get as much public comment as possible, because that's what the agency desires. Now, I don't want to get too far afield, but the point being, we're in pre-hearing procedure right now. If we move to dispositive motion, then we're in hearing procedure at that point. So whether we can have, go pre-hearing to hearing and then go back to pre-hearing briefing, it's a bit awkward. I don't think it's necessarily
It's a lot awkward.
unauthorized. But that's why I bring it. This is an issue that Mr. Krieger and I could discuss, and it can be decided at a later time. But I just want to get it on the table so parties are aware of that.
There's an element of this that doesn't seem just, that we've been waiting for a hearing for 4.5 years. And the one hearing that we get is a hearing to determine whether or not our application is thrown out.
Mr. Bowen, so to address that point, the reason that this has turned from a 1-year process to a 4-year process is because you have 3 attorneys on this right now, casting
Not
the
me.
version. I'm just saying this has become a contested case. Contested cases take longer, longer amount of time to proceed through the agency.
And I want to point out that the delays aren't from the objectors, so there have been some delays from the applicants. Applicants want to hire an attorney, everything gets kicked. Oh, no, maybe
That was kicked a month.
on 1 month, I'm sorry. Maybe one attorney, we're not sure. They don't get an attorney. So there's a lot of delay going on.
There's not a lot.
Not 2 years,
Not 2 years.
2 years.
So
So
in respect, the council didn't have a quorum for quite a lot, and then we had COVID and everything else was going on, so.
And that's part of it. So I don't want to get, again, too far afield. I just wanted to put on the table the potential process moving forward. I think that we're probably not going to reach a resolution here, so that might be a decision that's made sua sponte by Mr. Krieger. Later down the road after the dispositive motion's been filed. I think we have the dispositive motion schedule in place now. I think probably that's what we should do, and then cross the pre-briefing bridge when we come to it. But again, this is Mr. Krieger's discretion.
So we'd started out with the motion filed by the objectors on or before the 25th. That's still acceptable.
Yes.
Briefing, yes.
To file the
Dispositive
motion,
motion.
and then the applicants would have to, to object or otherwise present their side of it. Acceptable? Well, I'm here now, if you
I
have,
understand.
you have some compelling, valid reason for extending it, I'll do it.
We'll accept that.
Okay. And so they have to submit those by August 5th, so if we were to hold a hearing in Tiverton, it would be sometime now.
That's right.
Okay. Anybody have vacation plans end of August, beginning of September? I haven't had a vacation since I started here last September, so. It's fine with me if somebody needs to modify those things. Okay, yep, any of you have anything else?
Thank you.
Mr. Bowens, Mr. and Mr. Bowen, anything else?
I appreciate the time.
Thank you. So this was all taped?
It was.
Okay, great. And we'll let them know how they can access that.
It can all be accessed on YouTube, just type in Coastal Resources Council on YouTube. All of our hearings will come up.
Great, thank you.
Thank you.
Thank you. Dean, you, the other matter that we had, we were waiting for a consent decree. Have an order. I know this, okay, but what I was waiting for, I want to make sure that the other, that was one part of the 5 parts.
Yeah. Yes, so the consent agreement. I have sent to Mark.
Okay.
Red line version.
Okay,
So, yeah, I'm just waiting.
all right, I just want to make sure that we were moving forward.
Yeah. Yeah, no, I'm waiting for Mark's response, not to put Mark on the spot.
No, I understand.
Yeah.
Thank you.
Thank you. Good seeing you. So,
Nice to meet you. Thank you. Sir. That's the- that's the thing.
it's been a pleasure.
Let's say you all know, just like, very close friend of mine, worked the day before mine, but I know Steve Johnson. He's a carpenter and master carpenter and he's on the other side of the.
Okay.
On the side of the bay. Exactly like I am. He's a good looking guy.
Oh, well, thank you very much.
Yeah, he's got a nice family.
We like to think we do.
So you guys enough time.
That's what I know it's down.
You want to look
Specifically says you want a copy.
Do what we can. Thank you so much.
Take care. East and south.
Just another conference going on here at the moment.
So I don't think so.
Yeah,
Yeah,
right.
so for appreciation, but call me if we.
Yeah, absolutely, yeah, sorry.
I understand. Okay, thank you.
Good seeing you again.
Thank you.
Take care.
Started getting hot in here, I swear, the meeting moved along.
Thank you.
Right, take care.